Hi, my name is Eunice Tolu Olatunji. I'm a lawyer, a mediator, and a mediation advocate. As a mediator, I sit as a neutral and help parties facilitate settlement. And as a mediation advocate, I help my parties or my clients submit to mediation and allow them to resolve their matter using an amicable resolution. So you're welcome to this channel. So in this channel, we talk about law cases that have happened and how it has been resolved and things that you can learn from the legal veranda. So one of these days, I was at the High Court in Ota, and a man came in as a petitioner that he wanted a divorce. The judge asked the man, "What's your name?" He mentioned the name of the petitioner on the record. And the judge asked again, "Do you have any means of education for you?" He said no. So the judge asked the orderly to approach the man and check his pockets. Maybe it can be identified with anything. And lo and behold, the man was impersonating the petitioner. He was not the petitioner. Immediately he got to know that he's been caught, he started crying. A grown-up man, a family man, and was weeping and weeping and pleading for mercy. The judge said no, despite the plea of all the lawyers asking for the judge to forgive him. And the judge mentioned that it has been a reoccurrence thing, that the other time he forgave someone, and when he got outside, his colleagues were telling him, "Oh, you didn't pose very well. That's why the judge got to know that you're not the petitioner." I've heard of so many instances that people will say, "Oh, you just go and get divorce certificate," and that is it. The man I was talking about went to jail that very particular day. The judge did not pardon him because that is even perjury. Getting into a witness box, saying that you are somebody that you are not, impersonating, forgery, and all kind of crime. I don't know how the matter ended, but I know the man faced the wrath of the law. Another time, a friend of mine called me from Canada that a friend of his wants to get a divorce in Nigeria and they're calling prices for him. And the eyes divorce so serious, and you just go to the magistrate court and get a divorce certificate. So many people act in ignorance. And you know one thing, ignorance of the law is not an excuse. Some people do not know how it works. So it is important that you get a lawyer to direct you so that you will know how to go about things. A divorce that is given to you under 3 months, you should know that is fake. A divorce document given to you without you stepping into the court or the other party stepping into the court to testify, it's a fake document. Parties cannot, by agreement, divorce. What you can have is a terms of settlement. Maybe in the case where there are children of the marriage, there are properties to be settled, or there are so many things like monetary claim that parties are dragging with each other. You can have an amicable settlement by sitting down, drawing that a terms of settlement that will regulate your relationship going forward. You can have an agreement as to the arrangement for the children of the marriage. You can have an arrangement as to the sharing of joint property, but you can't have an agreement dissolving your marriage. You have to get to court, and it is the judge that can pronounce dissolution of marriage, that can pronounce the decree that the marriage has been dissolved. Even when the judgment has been given, you still have to wait for another 3 months before it becomes absolute. So let me take us back to the process of divorce. How is it done? You start the process by petition. There's only one ground of divorce, and the ground is that the marriage has broken down irretrievably. So in proving that the marriage has broken down irretrievably, there are about 9 facts that you can rely on. One of which is refusal to consummate a marriage. When parties have been married and one of the parties refuses deliberately to meet or have sexual intercourse with the other party, that could be a ground for divorce. That could be a fact to be relied on in arriving that the marriage has broken down irretrievably. Before you can rely on that, the party who has been denied sex has to have made demand, and the other person refuse deliberately and intentionally to consummate the marriage. So that fact can be relied on to prove that the marriage has broken down irretrievably. Another fact that could be relied on is the fact that parties have been living apart for a continuous period of 2 years. People often confuse living apart for a continuous period of 2 years with living apart for a continuous period of 3 years. When parties lived apart for a continuous period of 2 years and both parties do not want the marriage again, then you can rely on that fact. But where one of the parties is still believing that, this marriage can still work, I'm not going to let you go, you cannot rely on that 2 years separation. Then for the 3 years separation, whether or not party want the divorce, if it is proven that parties have been living apart for a continuous period of 3 years before filing the petition, that would be a fact good enough to show that the marriage has broken down irretrievably. Living apart for a continuous period of 3 years will not work for you. Maybe where parties actually agreed that, okay, I'm going on a transfer, you stay here. So that part, the separation was not to be living apart, The separation was not because you are having problem, but because you want to further your career, because you want to, for the common good of the family. So I hope with this, you've been able to distinguish between living apart for 2 years and living apart for 3 years. To rely on living apart for 2 years, both parties must have been tired of themselves that I don't want this marriage again, go ahead and file. Then for the 3 years, whether or not one of the parties want the marriage will be deemed to have broken down irretrievably where parties have lived apart for a continuous period of 3 years. Another fact that you can rely on is desertion, where one of the parties have deserted the other for a continuous period of 1 year before the marriage. Before the presentation of the petition. Desertion could mean in terms of refusing to carry out your marital obligation. And the party that will rely on desertion will not be the party that is actually guilty of desertion. If you are the one that left the matrimonial home, then you cannot rely on desertion. It's the other party that can rely on desertion, that you have deserted him or her for a period of 1 year. Another fact that you can rely on is the issue of adultery, where one of the parties have committed adultery and the other finds it intolerable that I cannot cope with this, then it could be a grant or it could be a fact that you can rely on to have the marriage dissolved as being broken down irretrievably. But where the adultery has been condoned, you are forgiving the person, you cannot rely on that fact. Except where the adultery has been continuous. So the previous one you have left it and the man or the woman continue in the act of adultery. So the subsequent one that you have not condoned could be a fact that you can rely on to say that the marriage has broken down irretrievably. In my next video, I will continue with the other fact that you can rely on in proof that the marriage has broken down irretrievably. If you have any question on what we've said, kindly drop it in the comment box. And thank you for coming around.